everyone. I'm Lauren McKenna, Chancellor of the Philadelphia Bar Association, and I wanted to welcome everybody to today's program. This program is being attended by over 300 people, and I think is probably one of the highest attended programs that I've participated in a long time. So we thank you all for joining us. On behalf of the Philadelphia Bar Association, the Philadelphia Trial Lawyers Association, the Philadelphia Association of Defense Counsel, and the Philadelphia Bar Association State Civil Litigation Section, we welcome you to the program today to discuss virtual discovery and conduct the Zoom training that I think is imperative for us all to understand. This program is truly a collaboration of all of those organizations, but also the court. And I wanted to thank the Honorable Dan Anders, Supervising Judge of the Civil Division, who's joined us, Pete Devone, Manager of Discovery Court, and Stephen Wilco, who is the Director of the Office of Judicial Records, who will be conducting the training today. We very much appreciate this opportunity to collaborate. This has been a challenging time, and the ability to do something like this and have so many attendees present and participate is just a wonderful opportunity for our profession in Philadelphia. So we will be proceeding today with many people on the program. As Tracy McCluskey from the Bar Association indicated, please do keep your computers, microphones on mute. That's essential so that we can make this as streamlined and easy to follow as possible. And we will also be allowing questions to be posted in the chat, whereby people can post questions and they'll be taken by the panelists as they're able, likely towards the end of the program. With that, I'd like to turn the microphone over to Dan Jack, who is president of the Philadelphia Trial Lawyers Association. Dan?
Thanks, Lauren. I echo in the gratitude to the Philadelphia Bar Association, PADC, and of course, the Philadelphia Court of Common Pleas, not just with their efforts in terms of setting up virtual discovery court, but in all of their efforts, recent efforts, Herculean efforts in getting us back into courtrooms safely and as soon as possible. So I'm looking forward to the program. I'm happy on behalf of PTLA to be part of this great program. And with that, I'm just going to turn it over to Dan Furhat from PADC to say some words. Thanks again.
Thanks, Dan. And yes, my name is Dan Furhat. I'm the president of the Philadelphia Association of Defense Counsel. And I too wanted to thank Judge Anders, Pete Devon, and Stephen Wilco, not only for putting together today's training program, but also for all of the transparency and the ongoing effort to keep the entire Philadelphia bar community informed of the status of the courts during the pandemic. And as most of you probably know, the court, under Judge Anders' leadership, recently published comprehensive protocols and guidelines for conducting in-person jury trials. And right around that same time the guidelines were published, the court also put on a program in conjunction with PADC and PATLA in order to update the bar on the resumption of in-person jury trials and to discuss the protocols. And not only did Judge Anders share the written materials for that program with representatives of both the plaintiff's bar and the defense bar, and strongly encouraged folks to circulate the materials to the Philadelphia bar community at large, he's also been conducting periodic in-person tours of City Hall so that attorneys can see for themselves what the courtrooms will look like. I think today's training program is yet another example of just how committed the court is in making sure that cases continue to move forward safely so that all parties can get their day in court. And one final point, and then I'll turn things over to Judge Anders. I echo the sentiments of my colleagues. I think it's terrific that PADC, the Philadelphia Bar Association, and PATLA are all hosting today's program, and that we've been able to work collaboratively to assist the court in the important work that it's doing. So on behalf of PADC, I just wanted to say thank you to Chancellor McKenna, Dan Jack, Jordan Strakowski, and everybody else who's been involved, and for your ideas and the professionalism over the past several months. So with that, I'll now turn things over to Judge Anders. Thank you.
Good afternoon, everyone. And first to Chancellor McKenna, thank you so much for the leadership that you have demonstrated and making the resources of the Bar Association available to us. Tracy McCloskey, you can't find anyone more professional in organizing these type of Zoom events. To the two co-chairs, Denise and Jordan, you've been essential partners with us as we have been demonstrating our commitment to resuming jury trials. And of course, the two Dans, Dan Furhat and Dan Jeck. It may have taken a pandemic to put us together in such a strong collaboration between the courts and the both sides of the bar. And the number of people that we're having involved in these town hall meetings and the trainings is really unprecedented. Last week, we commenced in-person jury trials by selecting 3 jury panels. We had more than enough jurors report. We had 85 jurors report. We were only looking for 80 on Thursday, and we had 50 report on Friday with the goal of only looking to get 40. The lawyers who examined those witnesses, I spoke with one set of them on Friday afternoon, and for a panel of 10 jurors, they only went through 24 jurors to get the 10 that they needed. So they weren't even approaching the full 40 that we had offered to them. We of those 3 juries that were picked, 2 went forward on trial starting on Monday. All of our juries are available on live stream. So if you go to the court's website, there's a live stream link. You'll have to know which judge is trying the case. And, of course, we had a few snafus. We realized that we have to re-engage the sound system every 90 minutes or it'll cut off. But we're learning from each of these experiences. We've had positive feedback from the jurors when we gave them feedback forms, and some of them completed them, and they were excited to participate in these jury trials. I probably have escorted maybe 80 lawyers, maybe closer to 60 lawyers through City Hall on these tours. And I've told Denise and Jordan that I will do them on the first Friday of every month. And I forget the time, but I think Denise can remind me on the time. In April, the first Friday is Good Friday, so we'll do it on Thursday, April 1st. But we're excited to be back and doing these on a limited basis. We are doing them in an environment that is conforming with all the protocols, both from the CDC and in compliance with all the directions and directives that we've received from the Philadelphia Public Health Department. The protocols may seem a bit, maybe one word is severe in terms of how we're requiring lawyers to remain seated at all times, but they're really essential to make sure that everyone is going to be protected in the environment, and we're conducting trials as safely as we can. One of to move towards today's program with the Discovery Court, we knew that one of the key parts of moving cases is to make sure that you can access Discovery Court quickly, and that you can get a disposition of your motion within a defined amount of period of time. Pre-COVID, that was typically less than 10 days. And with the program that we've now put and the protocols we have in place, it will now be 3 weeks from the date that you file the motion to the date you'll have a hearing with one of the team leaders. You can, of course, resolve it earlier with the various different recipes that Steve and Pete are going to talk about. But that time frame is now reduced to 3 weeks. And we think it's a good program. It's also a program that we envision will remain permanent. We'll make sure that it's working well, but I think this is one of the ways that the court is probably going to permanently change. And so having Discovery Court held virtually as opposed to in person is one of the improvements that we are now learning from as a result of the pandemic. Steve Steve Wilco and Pete Devon probably don't need any introduction, so I'm not going to give a lengthy introduction to them. But I will say that they're two of our senior directors in the FJD. They have been valued partners in everything that we've been doing, and they're very committed to make sure that this process goes forward. This is not as complicated as rolling out the electronic filing system, but it is a substantial change of how we approach the Discovery Court program. And so with that, I will pass it off to Steve and Pete.
Thank you, Judge. So I just want to start by saying, thanks for the opportunity to reach so many people at one time is a big deal for us. So I'm the Deputy Director for the Office of Judicial Records. I'm responsible for the civil side of the House. Office of Judicial Records, we are responsible for the e-filing review office, motions program, and Discovery Court, just a few of our departments. Everyone knows Pete Devon. As the judge said, he doesn't really need an introduction, but he does an amazing job managing the Discovery program. What we wanted to do here is we wanted to kind of go through the new protocols that are set to take place on Monday, March 15th, so it's right around the corner. And I wanted to demo the e-filing screens and how they will appear starting on Monday, March 15th. Was mentioned about questions. I think I'll be able to cover everything in the demonstration, but I'm sure there'll be some things that you'll want to ask. Throw it in the chat, and Pete and I will keep an eye on that, and we'll leave some time to go through those questions if we didn't answer them in the demonstration. The good news about this is that the changes may seem significant, but if you filed discovery motions in the past several months during pandemic times, this is a slight change from that. If you haven't filed since pre-pandemic, it's a major league change for you. The protocols have been posted. I think they've been distributed through different listservs. There's a link right on our e-filing login page. There's just a link to click there, and you can download them. Check them out. Get very familiar with them. You don't want to be the 11th hour ready to file a discovery motion or how to respond, and you're trying to figure it out. But after this, you should be an expert. I won't go through the protocols line by line, but I'll highlight a couple things now, and then as we go through the e-filing screens, I'll point to some more things. The first major thing is that there is no hearing scheduled at the time the motion is filed. That's a change from the old practice pre-pandemic days. You filed your motion, you got a hearing, as the judge mentioned, a week or two out. So there's no hearing. Instead, you're going to get a control number, much like I think everyone's used to in the motions program. This way we can track it. We know when it was filed. It's unique. There could be several motions filed in one case, and the control number distinguishes one from the other. At the time that the motion is filed and that control number is assigned, we're going to give it this certification due date and a response date. That first date, the certification due date, that's where you heard a couple times about filing recipes or certifications. You'll have 7 days from the time that we accept the filing. And, I'll take a second to point out that, yes, sometimes you'll file something on a Friday night and we won't get to it until Monday. The date will kick off from Monday when we accept the filing. So the first date will be 7 days from when we accept the motion. And the response date, if there is opposition, will be filed 7 days from that certification date. So we don't want to cheat anyone on their time for filing what they need to file. If either of those dates fall on a weekend or holiday, obviously, we give the next business day. So now I'm going to bring up and share my screen so we can see the e-filing screens as they will appear moving forward starting March 15th. What you see here is our current login page, and I just want to bring this up quickly so you could see that on our little bulletin board here, we got a couple announcements, and most conducive to what we're talking about here is that we have adopted these new protocols effective. You can click this link and bring up the document. Again, take advantage of looking at those, spend a little time digging through it. After you log in, this is going to be the screen as it'll appear starting Monday, March 15th. The first thing that I want to point out to you is the left-hand side, and a lot of you are probably familiar with our filing areas. You know, when you start a new case, you file something existing case like a preliminary objections or just an entry of appearance. But now you have this discovery court filings area. One of the big changes that we wanted to make, Pete and I talked about a lot of times, was that you kind of had to go to different places to get to file something related to a discovery filing. Now everything is going to be contained in this one area. So if you have a discovery motion or you have a filing that relates to a discovery motion, you're going to want to get in this area here, the discovery filings link. And you can see it kind of indicates that it's the discovery motions, it's the responses, it's the certifications, everything that relates to that discovery motion. I'm going to hit now the actual screens where the categories will be displayed. And I'm going to bring up a fake case here. And so I put my case number in, get my case caption back, and I kind of just confirm that I have the right case. And what you're going to see, much different than you'll see today, is there's many categories now. Not many. There's 4 categories there that you can file what it is that you're attempting to file. First of which, you're going to be filing discovery motions. So you're going to be able to click on the discovery motions and then a dynamic drop down of all the different motion types. You know, all the typical motion types that you would have seen on the screen before. We did add one for pre-complaint discovery that wasn't there before. So I just want to point that out, that if you're filing a motion for pre-complaint discovery, it is going to go through this discovery motion portal. If for some reason you get real creative and you can't find something that matches, we do have that other option there. And then you can enter a short description about what it is that you're trying to seek from the court. So that's kind of the motion area, not much different than what you're used to, just kind of lumped together with other filing options. The next one I want to touch on is the certification area. This is where you want to file your precipice to indicate the status of the motion. So I mentioned that when you file your discovery motion, you're getting a control number, a certification due date, and a response date. So that first thing that has to be filed is the certification that has to be filed by the movant only, not the respondent. That's a question I think Pete gets a lot. You know, who is supposed to file the certification? The movant hasn't done it yet. We're only accepting the certification precipice from the movant. So the movant comes here prior to the expiration of that certification due date. They tell us, what is the status? Is it contested? Is it submitted by agreement? Is it uncontested, or is it withdrawn? You guys worked it out, or you realize you shouldn't have filed it, you can certify that it's withdrawn. I'm going to mention this now, and we may touch on it a little bit later. If for some reason that you don't file your certification by the due date, that motion is going to get dismissed without prejudice. So you have to comply with the protocol. So if you file the motion, you have that 7 days to file your certification. You make your best effort to speak to your opponents. If for some reason you do not file your certification, it will be marked dismissed without prejudice on the docket. Other point there, just to make it super clear, the dismissal will happen not at the expiration of the certification due date. It'll actually happen at the expiration of the response date. It's just kind of a tracking mechanism that we have to deal with in-house here. So if the certification due date is today and the response date's not until March 17th, it'll be shortly after March 17th that it'll be marked dismissed without prejudice, just to make sure it's super clear there. Answers and responses and replies to discovery motions. So this is kind of a bigger category with more specific filings in it, much like what you would see in the regular pretrial motion categories. This is where if something is certified contested, the respondent's going to come here to file their answer in opposition. But it's also a place that after a response is filed, the movant may, if necessary, file a reply or a supplemental brief, or maybe they forgot to attach a certificate of service or something that they didn't attach their original motion. They can use this category and select the appropriate option. All right. But again, answers and responses in opposition are really only going to be taken if the motion is certified contested. We have to let it play out. The movement has got some work to do. They're going to file their motion. They're going to file a certification that it's contested. And then that period for filing the response is in play. If there is no certification that's contested, Pete and his staff will probably be communicating to you that they're not accepting the filing. There is a category here for withdrawing the discovery motion, slightly different than the certification that it's withdrawn. You know, the certification precipice is in that first little period of time, but then maybe down the road after it's been certified to contested and someone's filed a response and it got listed for hearing, whatever, you might want to just withdraw that motion. This is the category that you would want to use there. I'm going to now pick a filing option and move on to some of the other screens because I think I touched everything that you'll need to see here. Actually, one thing I wanted to point out is that if you file a motion, we are going to display the discovery deadline. And as always, we're not going to accept the motion if it's beyond the discovery deadline. I think Pete would probably tell you there's some circumstances where we would take it, but for by and large, we're not going to accept it, or if it's within 45 days of the ARB date. Also, Pete will touch on this a little bit later too, that you do have the opportunity to indicate that it needs emergency attention. There's very limited circumstances where emergency attention is probably appropriate, but if you need it, you can click that box there. And then Pete and his staff will, at the time of review, communicate with you how it's going to be handled. So I'm going to select the certification and I'm going to indicate that the motion is contested. I'm going to move on. Nothing different here than you're used to. You select who you're filing for. Again, maybe I'll take an opportunity here that this bottom section here, it may be for something or conducive to discovery practice where maybe you're not a party to the action, but you need to indicate who you're filing for. It's a third party in some way. You want to use this bottom portion of the screen to indicate the party's information. It's not that they'll be made party to the case. It just allows the filing to go through and our docket kind of reflects things appropriately. The third screen here is something different that you may be used to seeing in the regular motion screens, but in discovery court, we never had anything like this. So what I did was I selected that I'm filing a certification, and what I've done here is, or what the screen has done is brought back any open discovery motions that are waiting for a related filing. So in this case, in this dummy case I have here, there's 2 discovery motions outstanding. You can see that it gives the control number, the docket text that indicates the type of relief sought, the certification due date, the response date, who filed it. It's important that you pick the right one here, right? I'm sure we've all done it. You got 15 motions in limine and you say I'm responding to one and you just click the wrong box or wrong button. Just take your time on this one. Make sure we link up the responses and certifications to the right open motion, because as we know, there will be several open. This last section here that says if the control number is not listed, enter it here. So there's a couple reasons for that, is that maybe the motion got closed improperly, just maybe by clerk error, but also we have this bridge between the new protocols and what we've been doing for the last several months. So for the last several months, if a motion was filed, there wasn't a control number assigned to it right at the time that it was filed. It only got a control number after it was certified contested. So we still have some of those to work through in the coming weeks. I think, there's that 20-day period for the certification. So we have to bridge the 2 protocols here. So I worked this out with Pete a little earlier to say that we want to make sure that you can get it through. You're not going to know the control number. So simply putting all 9s in this box will be a good indication to Peter and his team to review the filing, make sure that we either have to give it a new control number or reopen one that got closed inappropriately. So if this was a certification that I was filing for a motion that got filed last week, I'm going to put all 9s in here to say, hey, this motion is contested, and then Pete and his staff will assign it a new control number. Then anything that happens subsequent to the certification, like a response, that new control number will pop up on this screen. Right, I'm just going to select one and just go on to the next screen. After this, nothing too new here. It's where you have an opportunity to update your contact information. Always take a look at this. Anything that you update here is going to update in our case management system. So if you have a new email address or you have to add a new email address, just use this opportunity here by clicking the update information area. Screen 5, I think everyone's getting used to. This is where you upload all your documents. In discovery court, I'm sure there's many times where there's confidential information contained in the motion, so pay special attention to this. I'll take the opportunity to just say that there is a difference between confidential information and confidential documents. Take a look at the policy. It does a pretty good job of distinguishing it. If the document contains confidential information and you say yes, the system expects you to give us a redacted and an unredacted version. If you have a document like tax returns or something like that that's listed as a confidential document, when you say yes, you're just going to upload that document, not a redacted version per se. Let's see. All right, let me go back to the first page here. And I want to share, when you file a new motion, what the email acceptance will look like, because that is different than what you will see. I hope everyone is seeing that. Pete, can you give me a thumbs up? Can you see that screen? All right. So you can see here it's a e-filing acceptance. Got our test case here. Motion control number right at the top of the email. The certification due date is there, response date there. So at the time that this filing is accepted by Pete's staff, the filer and anyone who's an e-filer party to the case is going to get an email that looks like this, indicating all of that information, which is obviously important. I always like to point out that we indicate who we were able to electronically notify. The rules of civil procedure, specifically 205.4, if we notify them, that constitutes service for you. But if for some reason the parties to the case that don't have e-filing account, we're not going to be able to notify them. That's on you to make sure that you get the motion and all of the right information to the respondent. All right. Now, if an answer is filed in opposition, so we have the motion filed, there's a certification, that indicates whether it's contested, uncontested, by agreement, withdrawn. Actually, one point I want to make about the uncontested and the by agreement. Those recipes and certifications, they should have the agreed upon order or the order being submitted uncontested attached to the precipice, and that is subject to discovery court staff review. So Pete and his staff are going to look at those recipes, and if you say this motion's uncontested or submitted by agreement, and the order attached contains some language it just doesn't fly, like, we're extending all case management deadlines or something like that. You're going to hear back from Pete and his staff to say you got to correct that, or they may not accept the filing if it has inappropriate language on the proposed order, or not acceptable language, let's put it that way. So if it's certified contested, we're expecting a response. When the response is filed, let's say it's certified contested and no response is filed. Let's start with that scenario. So certified motions filed, certification due date, filing party movement says it's contested, and then no one files a response. Pete and his staff are going to have track these motions, and at the expiration of the response date, they're going to see, okay, this was certified contested. I see no response here. They are going to then assign it to the appropriate judge for review as unopposed. So it's not going to be entered automatically. You should expect some kind of order entered by a judge or some other communication about what they're going to do with that motion. But at the expiration of the response date, it'll get assigned to a judge for review as unopposed, and then ultimately some kind of order will be entered on the docket and notice will go out to everyone. So that's sort of scenario one when something's certified uncontested. The other scenario is when something is certified contested and there truly is a response filed by the opposing party. If the motion is certified contested and there is a response, at the expiration of the response date, Pete and his staff are going to go through those motions and they're going to schedule them for a discovery hearing. So this is the significant change from what we've been doing the last several months to Monday. That at the expiration of the response date, certified contested, and there's a response filed, Pete and his staff are going to get it listed for a discovery hearing. Going to kind of go back to the way things were in that each team leader will have an expected day and time that their motions will be listed. The big difference now is we're going to do them remotely via Zoom. And that's something that I'm going to have Pete talk in depth a little bit about. How the actual hearings are going to be conducted, but just know that at the expiration response date, it's going to get listed for a hearing, and I want to bring up the notice of that event. Pete, another thumbs up. Can you see that? Great. So when Pete and his staff actually schedule this for a hearing, you're going to get a notice that looks very similar to this email. If for some reason someone's not an e-filing user, we'll send it out in regular mail, but we are sending this to all the e-filing users to indicate that the motion is scheduled for a particular day and time and which judge they're listed in front of. It'll be the judicial team leader, right? The major jury team leaders, commerce team leaders. You'll get listed on the particular day that's predetermined. And it's about 7 to 10 days from the expiration of the date, as the judge was saying. We're hoping that everything kind of wraps up within the 21 days. What we're trying to do is make the information to join the Zoom meeting readily available, and we're trying to make it static. So if you get listed for a discovery hearing in front of any of these judicial team leaders listed here that I'm sort of highlighting, Judges Anders, New, Carpenter, Cohen, Shreves, Johns, you're going to join the meeting by clicking this link right here. And you'll do that at the time and the date and time that was listed on this notice. This meeting information is not going to change. It's going to remain static. So if you ever have a discovery hearing in front of any of these judges, this is the Zoom link that you're going to use. Discovery court for commerce, just slightly different, but it is, again, static for each judge, each team leader, Judges Glazer, Right to D, and Gerasi. They just have unique links, but again, they will be static for those judges. So if you have a discovery hearing in front of Judge Gerasi, you're always going to use this link. So you can kind of keep it. At some point, maybe those will get updated, maybe in months, I don't know. But right now, the plan is to keep them static and just paying close attention to the different judges that would you'd have your hearing in front of. I'm going to take 1 second to look at the chat here and see if I can hit any questions. There was a question here, will discovery motions be rejected after the discovery deadline? I think I did answer that. We still will apply those rules, or if they're within 45 days of the arbitration date. I have here that if they don't certify, if your opponent doesn't certify in time, again, you have to do that within the 7 days. If not, it will be dismissed without prejudice. Will the certification, it's a good question. Will the control number, certification due date, and response date also be on the docket report? And yes, it definitely will. The docket entry will be very clear as to each of those pieces of information. And one thing I failed to mention, we also were able to, you may be used to seeing control number stamped where the case ID is at the bottom of the document. The certification due date and response date will also be stamped on the document. It was a little creative thing that we pulled off there. So when you get notice of a motion, you can see that stamp right at the bottom. Can you file the motion and the certification at the same time, same day? I guess so. I mean, if you know your opponent's stance, you guys have kind of like talked already. I don't see that being a problem. Obviously, they would be consecutive, whether they're minutes apart or half a day. Let's see. Are the Zoom hearings public? Yes. You may have noticed that there is live streams on the court's website. These will be there as well. There'll be it won't be, so you wouldn't go to Judge Anders' live stream. You'll see a discovery court for Judge Anders' live stream. So there'll be a sort of Judge Anders has his own Zoom, and then there's a discovery court for Judge Anders and the other team leaders. Let's see if a press view discovery order. If a press view enter discovery order by agreement or uncontested is filed, will we be getting a fully signed executed order back from the court? And no, that you are not. That's still the same as what we're doing now. It'll be considered entered based on that precipice. That's why there's a key in the wording of the order, and Pete and his staff's review to make sure that we're not accepting a precipice and entering an order that has language that's not acceptable to the court. Will the motion need a notice of presentation? No. I know the local rule does say that, but you will not need a notice of presentation at this point. How long after a motion is responded to do we expect a hearing date? So about 7 to 10 days after the expiration of the response date, that's when a hearing date would be listed. How to get an order signed when a third party is on. I might have to come back to that one. What if you can not get a response from your opponent within 7 days? What do you put in the certification? So I think we tried to craft the precipices and certifications to sort of say that you've made reasonable efforts to get a hold of your opponent. And if you can't, unfortunately, you have to sort of assume that it's contested. Then maybe if there is no response filed after that certification has been filed, it may get assigned to a judge that's unopposed. But unfortunately, if you're not able to make that connection in those first 7 days, it will, you'll still have to mark it as contested. What if you want to file a reply to the response? So the system allows it. The time is short on purpose, right? We want to get these things filed and disposed of. So you got to do everything within those timeframes that have been established. So really, there's a 14-day window there to get answers and replies in from the time the motion is filed. So I don't want to take up much more time. I'm going to turn it over to Pete. And I know, Pete, that I probably didn't leave a ton of stuff for you, but if you could fill in the blanks, I know I missed something here or there.
Okay. Did a good job, Steve. I'm just going to fill it again. Definitely some of the blanks here. So basically, once you file your precipice, as we talked about it, either the precipice is by agreement or uncontested. The order that you file with your precipice is your order. You will not get a signed order. Getting back to the chat, how about if it's a third party? Good question. The third party sees a blank piece of paper. There's no signature on it. That's where you contact discovery court and say, hey, this is a third party. They're not abiding by the precipice. I need a judge's signature. It went in by agreement. That's fine. We get that. I'll email it to me. I get it up to the judicial team leader. We tell the judge, this is the deal. It's a third party. They're not accepting that. Fine. The judge will sign it. There's not a problem there at all. Also, if it's an issue of a subpoena for out of state, you're bringing a blank order out to judge in Missouri. Well, that's not going to work. We know that's not going to work. Again, email me. We get it to the judge signs them, and then you could go out and get it signed. And again, the third party must be served, okay? Service is a big thing on third party. So you should be making your service on them. And again, all the efforts there of a third party needs to be served. So we will look at your motion to see what you did for service and what have you. So again, you will not get an order if it's by agreement or uncontested. let's go back to the filings, just to touch base there. Motions, I think Steve actually answered that question. It's still the same way. If it's past the discovery deadline, discovery court will reject that motion because it's past the discovery deadline. The only motion that we will accept past the discovery deadline is a motion for sanctions coming back on a previous judicial order. That is it. Now, if there's a quirk here and there, the case, they did this, again, that's where you send me a letter, CC and all counsel on it, we get it up to the judge, and only the judicial team leader can tell discovery court to take in a motion after the discovery deadline. And that's 1 out of 1,000 or what it may have been. Good faith effort, still out there. You still need to reach out to opposing counsel and try to work it out. You know, just because it's by Zoom and this, and we file press, you reach out, try to work it out before you file that precipice. The judges may or may not, I'll leave that up to the judge at the Zoom hearing. What have you done with this motion to try to resolve it? Still the ultimate question. So the good faith effort is still there. And again, the good faith effort is a long-standing good faith. Before you file it, what did you do after you file it? And then what did you do after you got your hearing date? And what have you done today to try to resolve it? So that's a long, outstanding, good faith effort to try to resolve this motion. So let's see what we're going to do here. So once you file emergency motions, let's just top on the emergency motion. What is an emergency motion? An emergency motion is not the discovery deadline is right around the corner and I need this motion filed and I need it now and I need a judge's order. That is not an emergency motion. The court will not deem that emergency motion. Only the judicial team leaders, again, I have no say in what's an emergency or what's not an emergency. The judges have to give us strict guidelines of what is an emergency and what is an emergency. And the emergency is an emergency motion for protective order because they want the corporate designee to come in 2 days and to do it live or by Zoom. We need a protective order to make sure that that doesn't happen within a 2-day, 3-day period. An inspection of a property. We need to get an inspection of a property because something is happening. They're going to tear it down. They're doing some work in the property. That could be deemed that as an emergency motion. Destructive testing on a product's liability case. They're going to take it in. They're going to do this destructive testing. We can't let that happen. That could be deemed as an emergency motion. All right. So again, it's pick and choose. It's not everything that you think is your emergency is necessarily the court's emergency. So that's a big thing there. And again, the discovery deadline coming close is not an emergency as long as you file your motion. If your discovery deadline, again, it's the first Monday of every month, you file it on that first Monday. It's a good motion. It's 20 days if it gets a hearing, if it's contested, still a good motion. Arbitration rule still in effect. 45 days of ARB, you cannot get a motion within the 45 days of ARB. So just let me touch on that because we all know what's going on with the ARB Center. There's dates on the docket that says I have an arbitration hearing. It says January 15th, 2020. The ARB did not happen. An AJPT conference either happened or did not settle it at that point, but it's still a viable case. Arbitration Center is backed up. We all know that. We don't have to tell anybody that anything new that nobody knows. So we've already talked to Maureen over at the ARB Center. Discovery Court will accept that motion from that says the ARB date of January 15th. We know it's still a viable case. The ARB Center just has not gotten to that motion to put it out somewhere, hopefully still in 21 or maybe even, I see some dockets, January 2022 on ARB cases. So we will accept that. We know what's going on. So if you file it, I know there was in the past, a couple of weeks ago, we were rejecting them. And then we got together with the ARB Center and says, we're rejecting a lot of these. What's going on? How can we help this instead of counsel just spinning wheels and trying to file motions and what have you? So we've talked about that. That's something that we're going to take care of. You file it, Discovery Court will accept it. Again, orders that are entered by agreement by precipice are uncontested. The time frame of that order starts with the filing of the precipice. So if your order has to production of documents within 20 days, when you file that precipice, the time frame starts on that precipice order. Okay? So that's something that we all get a phone call and, well, when does it start? Where's the order? No order. Time frame starts at the filing of the precipice. Another question that I got today, actually, was about 15 minutes before we came on here, talking to counsel, and they said, oh, I see the new COVID protocols are coming out. Will you change your protocols again on March 15th? The answer to that question is no. These are not COVID-19 protocols. These are new discovery court protocols from here until infinity and beyond. Okay, so this is the way we're going to do it. We may tweak it here and there during the course of it to see what works, but this is the process and this is the way it's going to be. So let's talk about contested matters that has a motion, a response, and what do? So we get the motion, we see the responses filed. This is right for a hearing. We're going to schedule a hearing. And again, just like old discovery court, as we'll call it, each judicial team leader and each team has a date, specific, and time where these motions are going to be heard. And I'll go through them. The Day 4 2021 program with Judge Anders as the team leader. That will be Monday at 9 o'clock. Again, you click that link for Judge Anders. That goes right to Judge Anders' courtroom. Judge Arnold New, Day 4 2020. Again, Monday, 9 o'clock. Click that. We'll get into Judge New's courtroom. Tuesday, Day 4 2019. Judge Carpenter, again, Tuesday, 2019, Judge Carpenter. Click the link, you're in her courtroom. Wednesday, Day 4 2018, Judge Cohen. Again, click the link, you're in the Judge Cohen's room. Arbitration, non-jury cases, Judge Shreves Johns. That's going to be on a Thursday. Again, at 9 o'clock, click on her link, you're there. Commerce program, Judge Padilla will be at Tuesdays at 10 o'clock. Judge Zarassi, Tuesday at 10 o'clock. Judge Glazer, Friday at 9 o'clock. Again, Steve told you how to get to all the links. I know we're throwing a lot of information at you today. This information will be out there on our website. I think Judge Anders even put some links out there for the protocols and what have you. I am working on a step-by-step guide, basically what we're doing here today, breaking it down a little more for either the secretaries or the paralegals. And once you get in there, you hand it to them and they can go step-by-step of how this process is going to work. So the Zoom links are there. So basically, you click the Zoom link. What's going to happen next? Well, you're going to see me. That's what you're going to see. It's going to be a cattle call. It won't be a cattle call 400 anymore, as we're used to in old discovery court. It's going to be the contested matters only. All the by agreements, the uncontested, and the withdrawals at this point, 90% will say, are already off the board. Of course, you could come in on that Monday and say it's Judge Anders and say, hey, Pete, we just worked it out. Fine, you worked it out. Put the precipice by agreement in there. We'll take it off the list, and that gets filed. Again, cattle call, 25 cases. There will be, I will be there. I will have the 25 cases. You come through Zoom. What case you on? I'm on the Smith case. All right, you're number 8. I'm on the Jones case. You're number 9. It'll be the same way as old discovery court. Instead of the attorneys coming in, going to the list and looking for it, I will have the list. As soon as you pop onto the Zoom hearing, I will be there checking everybody in. Once we get a ready case, and everybody will be in the courtroom itself. Okay, there will be breakout rooms. If you want to go work it out in a breakout room, you'd say, hey, Pete, we're going to try to work this motion out. I want to go in the breakout room before the judge comes on the bench. Fine, I'll put you in a breakout room and I'll pop in every now and then to see what's going on. If you're in the courtroom and the judge makes a ruling, makes 2 rulings, and you say, hey, I got the same motion. I just heard 2 rulings. I know how the judge is going to rule on this. You know, hey, Pete, can we go into a breakout room to try to work it out? Of course you can. We're looking for the work it out. That's my famous words in the discovery court. Work it out. All right. Either be quiet or work it out. That's all I ever say. So again, discovery court in the courtroom by Zoom, pretty much the same as the live courtroom. but you'll see me there. We'll go everything one at a time. It'll be an open courtroom with a judge on the bench, breakout rooms available if you want to work it out and what have you. Let's see. Again, a lot of stuff here. The discovery court will be available for any questions or anything like that. We are available. I will make myself available throughout this process until we get it down through do whatever type of CLE, lunch and learns in a firm. A defense firm says, guess what? I got all these attorneys and secretaries and paralegals. Can we do a Zoom just with my firm? Reach out to me. We'll do a Zoom. We'll go over it one at a time and make sure each firm has it, all the information, what they need. You know, I'm always available by email, telephone. I'm here. We'll work all this out.
Pete, there's a few more questions I might want to try and get answered before we get off. All right.
Okay. Yep. And now I'm just going to make a pitch because I have 325 attorneys in a room. So I'm going to make a pitch. We're moving along with the jury trials and also with pretrial conferences. Again, we're having second level pretrial JPT conferences. So if anybody's available to sit as a JPT, please reach out to me. My email, everybody knows my email. If not, it's peter.devone@courts.com. We need all the JPTs we can because, again, we have AJPT programs, we have the regular major jury JTP programs, and then now we're starting back up our trial-ready JPT program, which cases have already went through a JPT, has already went through a pre-trial conference, and an order will be out there that all adjusters and anybody with financial interest shall appear for this JPT trial-ready program. I know we're running short on time, so I'm going to be quiet here and let's see if we got any more questions. Go ahead, Steve.
Be quiet or work it out, right, Pete?
Be quiet or work it out, and work it out.
All right. So just because I wanted to take advantage of this is being recorded, I just want to, I've been responding in the chat, but if you haven't noticed things in the chat, I want to mention a couple things. Discovery and aid of execution, not filed in the discovery program. That's going to be filed in the motions program. You know, the team leaders are kind of done with that case. It's post-judgment, so it's going to go through the motions program. Contested motions will result in a signed order. Either it's going to be after a hearing because someone filed an answer, or it's going to get assigned to a judge as unopposed and an order will get entered because there was no answer filed. But either way, if it's certified contested, 99 out of 100 times, maybe there's that one weird time, but there will be an order entered on the docket. Someone asked, are you definitely going to get a hearing if it's certified contested? You will get a hearing if it's certified contested and an answer has been filed. Again, I feel like I'm sort of saying the same thing in different ways, that if it's certified contested and an answer is filed, you'll get a hearing. If it's certified contested, no answer gets filed, no hearing, it's just going to get assigned to the judge as uncontested. There was a question whether this video will be available. I'll leave that to the organizers here. But we will have a sort of an illustrated guide, as Pete alluded to, that'll come from the court that kind of highlights the screens that I think a lot of your staff will like, just to kind of point out the different filing categories. The protocols are out there already. They're written really well because Pete and Judge and I wrote them. So. But if you follow them along, you should be able to, or if you read them, you should follow them easily. Someone asked about name changes. I would say to email Pete offline about that. He'll answer your questions there. And then someone did mention about the last 2 weeks. I did cover that during my little demo there, but just to kind of reiterate that anything that was filed prior to these new protocols, the only difference is going to be they don't have a control number yet, but all of the timeframes and the recipes still apply to pre-new protocols. So what will happen is on Monday, if you file a certification that one of the motions that was filed last week is contested, then Pete and his staff are going to give it a control number, and then the new protocol sort of work from there. So that's sort of the slight difference there. So it won't take long before we just kind of get caught up in everything that gets filed and get a control number at the time it's filed. I think
that's, and again, any
I
questions?
covered all the
you have,
answers there.
Call us. We're available. You call us. We know it's new for us. It's also new for you. We're going to work this together. We're going to work it all out together, and my staff and what have you. We're getting educated on it as we speak, and we'll get through it. It's something that once the newness comes off, if that's a word, newness, we'll all be fine. And again, we're looking to get your secretaries and the paralegals who are also involved in this up to speed with it also. So I'll be available to do whatever I need to do to make that happen. Any other questions or anything?
I thank everyone. We appreciate this time that you gave us, and hopefully it was we explained it well enough. But as Pete keeps saying, that we're available. Reach out to us, email, phone. We're here. Thanks.
Pete and Steve, thanks again. For those who are following along in the chat, we will make this recording available. I know it's chock full of really good information. So thank you again for your efforts and for coordinating with us and giving us this important information. Tracy, did you have something to close with? I saw you raise your hand.
So I was going to say thank you, Lauren. I just wanted to invite also Dan, Jack, and Dan Perrott, as well as the State Civil Litigation co-chairs Denise and Jordan, to add anything to this program as well. Thank you, Lauren.
Sure. Hi, much like Pete, I'm sorry. Hi, Jordan. While I have you all here, State Civil continues to facilitate tours of City Hall. The next one is going forward on April 1st at 2:30 p.m. If you are interested in touring any of the new courtrooms, please send me an email and I will get you on the list. I will put my email address in the chat. Thank you.
And thanks everyone for coming. Thank you to the court. Thank you to Steve. Thank you to Pete. Of course, thank you to Judge Anders. Also, thank you to Charles Mapp, who also asked me to pass along that on March 13th, a Saturday from 7 a.m. to noon, the court website and the e-filing will be down due to a scheduled power outage. But thanks again for your help, everyone.
Dan, Jack, or Dan Perrott, do you have anything to add?
I have nothing to add. I thanked everybody at the beginning. I think this has been a great presentation, and I hope everybody found it useful.
Okay, Lauren, I turn it back over to you.
Great. I think we're concluded. We're right at 5, right on time. Thank you, everybody, for all your time today. And I really appreciate you being with us.